Murder, R.V. Moloney. The defendant and his stepfather, who had a friendly and loving relationship, were engaged in a drunken competition to see which of them could load a shotgun faster than the other. Moloney won, and was then challenged by his stepfather to fire the gun. He did, killing his stepfather instantly. Moloney was charged with murder and convicted. He appealed, and the Court of Appeal allowed appeal to the House of Lords. Did the mens rea of murder require direct intent to kill or cause serious bodily harm, or was foresight of a serious likelihood of harm occurring sufficient? Whether the jury was to infer intent if they were satisfied that the accused foresaw that death or serious injury was a natural consequence of his act. The House of Lords allowed Moloney's appeal. He had not intended to kill his stepfather. Knowledge of foresight of the consequences of an action were to be considered at best material from which a crime of intent may be inferred. Where the defendant's purpose was other than to cause serious bodily harm or death to another, then the jury may infer intent if the consequence of the defendant's act was a natural consequence, and the defendant foresaw that this was a natural consequence of his act. The jury in such a circumstance should be directed that they may infer intent, but were not bound to infer intent, if both these circumstances are satisfied. Foresight of the natural consequences of an act is no more than evidence of the existence of intent. Manslaughter, R.V. Adomako. The defendant, Mr. Adomako, was an anesthetist. He was undertaking his role during an eye operation during which the patient was required to be placed under a general anesthetic. During the operation, and whilst under Mr. Adomako's supervision, a crucial tube became disconnected from the ventilator and the patient suffered a fatal cardiac arrest. Mr. Adomako was convicted of the manslaughter by breach of duty. Mr. Adomako appealed the conviction and questioned the legal basis of involuntary manslaughter by breach of duty. Dismissing Mr. Adomako's appeal, it was held that in cases of manslaughter by criminal negligence involving a breach of duty, the ordinary principles of the law of negligence applied to ascertain whether the defendant had been in breach of a duty of care to the victim. On the establishment of said breach of duty, the next question was that of establishing causation and, if this could be so established, whether it should be characterized as gross negligence and therefore a crime. This is ultimately a question for the jury, having regard to the risk of death involved. Asking themselves, was the defendant's conduct so bad in all the circumstances that it ought to amount to criminal assault? R.V. Miller. The defendant, Mr. Miller, had been the husband of the victim who, at the time of the alleged offense, had left the respondent and filed a petition for divorce on grounds of adultery. During this period, the defendant met with the victim and had intercourse with her against her will. This caused the victim to suffer significant mental distress. The defendant was charged with both rape and, in the alternative, assault occasioning actual bodily harm under Section 47 OAPA. An appeal was brought on the basis that the defendant had no case to answer. A husband could not rape his wife, as a wife impliedly consented to intercourse for the duration of the marriage. Whether the common law rule as to the implied consent of a wife remained good law, and, if so, whether there were circumstances, such as the use of force or violence, in which this consent could be revoked. This case also raised the question of whether psychological damage, expressed in the dated language of nervous hysteria, was capable of constituting actual bodily harm. That the appellant could not be guilty of rape, as the implied consent of a wife to have intercourse with her husband could only be revoked by court order or a binding separation agreement. In the circumstances, this consent had not been revoked. Nevertheless, a husband was not entitled to use force or violence for the purposes of exercising his right to intercourse. To do so would amount to an assault. Moreover, as a hysterical and nervous condition, 1954, 2QB 282, 292 Belinsky J, is a recognized form of bodily harm. Such an assault would constitute an offense under SDOC 47 Battery, Collins v. Wilcock. A police officer wished to question a woman in relation to